Welcome back to Law News Network. I'm Heather Hansen, and we have a phone guest today. We have Mark Eisenberg, who's a lawyer, who's here to talk to me about Halloween and all things legal as they pertain to Halloween. And I want to start with an article that Sky, one of our viewers, brought to our attention that says that in California, there used to be a law in a certain county in California. I want to make sure that I'm quoting this correctly. The Sim Valley City Council. They are overturning a law last week that prevented convicted pedophiles from engaging with trick-or-treaters. And a lot of you are frustrated and upset and confused by the idea that this would no longer be a law. But Mark, who has some special expertise in constitutional law, has an explanation for us. So Mark, can you get into that a little bit for us?
Sure. Thank you, Heather. So essentially, pedophiles who are typically registered sex offenders for whom the public is on constructive notice as to their whereabouts and residences because it's published by the state and by various counties, is under an obligation to refrain from interacting with minors. That's typically part of the ongoing probation or parole. But that only respects the pedophile's affirmative conduct. If somebody comes to his house, for instance, if a parent brings trick-or-treaters to his house, then the pedophile did nothing affirmative to engage those minors. Instead, it was the minors and their parents that sought to engage the pedophile. And there's no basis upon which to punish a pedophile for that type of behavior when he didn't institute it.
So as long as this really puts parents on notice that they need to be very well aware of what's going on in their neighborhood, because if the trick-or-treaters are coming to the pedophile's house, the pedophile is not going to get in any sort of trouble because he's not the one engaging with them.
Correct. He has an obligation to refrain from engagement with minors. However, if the minors come to him, whether it's for trick-or-treating purposes or to ask a question or to get directions, as long as the pedophile is shown not to have instituted that particular interaction, he cannot be punished for it. More than that, many municipalities are seeking to establish protections for the public against pedophiles that are contrary to what state law has established insofar as what a pedophile may or may not do and may get away with lawfully. So many of these municipalities that have put in place these more restrictive covenants, such as what it sounds like we're dealing with here, are stricken down as unconstitutional.
Let's move on to something else. There's a lot of questions about trick-or-treaters, and if trick-or-treaters are coming up to your house, are you liable if they trip over a loose brick or something in your walkway? And I guess the question is both: is that the case if you've put the light on and put candy out? And then the same question if you don't have your light on and you don't have candy out and you've tried to make it clear that no one's invited to come to your house for Halloween. Is there a difference?
There absolutely is a difference. If you're inviting members of the public, be it minors or adults, onto your property, you're under an affirmative duty of due care to act reasonably so as not to create an unreasonable risk of harm for persons coming upon the premises. So if you're laying out Halloween decorations, you cannot put a cord across a walkway that might create a trip hazard. You have to be careful with your wiring so that no one gets electrocuted. You have to be careful that the ground, is free of debris and doesn't create a trip hazard for young people or children or even their parents coming to the property. However, if you've given no indication that people are invited for purposes of receiving trick-or-treat candy or otherwise, then you're under no affirmative duty because they would constitute trespassers.
That's right.
In which case, you're under no obligation to protect them.
That's right. It's an interesting question. So if you want to avoid all liability, just be a Scrooge and shut off your light and don't give away any candy, I guess, is the answer.
That would be a safe bet, in addition to maintaining a policy of liability coverage through your homeowner's policy.
Right.
Because you never know what people are going to do. And just because you've taken every reasonable precaution in hopes that people don't enter your property, it's still going to happen. And in California, for instance, you're going to get sued for it.
Right. So you want to make sure that
best to maintain a policy.
That's right. Well, Jillian had a really good question. What if a child has an allergic reaction to the candy that you've provided? Do you think that that person who provided that candy is going to be open to any liability for that?
open to liability and being sued are two very different issues.
That's right.
Invariably, they're going to be sued. Whether they become liable has to do more with whether there was disclosure at the time the candy was given out. For instance, if the child says, hey, I have a peanut allergy, I just want to be sure that what you're giving me doesn't have peanuts, and then the homeowner represents that, no, there's no peanuts in this Mounds bar, and it turns out that he really gave him an Almond Joy, there's a problem there, and
Right.
there's likely liability. But ultimately, liability may rest with the parents, because if the parent knows that the child has a food allergy and does not accompany the child to the door to ensure that what the child is receiving isn't going to create an allergic reaction, it could well fall back on the parent, in which case there's really no exposure or liability.
I agree with you wholeheartedly. Here's an interesting one, and I actually did some research on this, so I have a little bit of insight on it. If you have a house that you think may be haunted, do you have to relay that information to a potential buyer if you're trying to sell? And how does one prove or disprove that a house is haunted? Are you aware of that Ghostbuster ruling here in New York, Mark?
I am not.
So I can answer this question, I think, for Sky. There was a case here in New York where the courts found as a matter of law that a house was haunted, and that therefore the sellers should have informed the buyers that the house was haunted. But that was an unusual case because the sellers were actually, before wanting to sell their house, they were publicizing the house as being haunted. They spoke to Reader's Digest about the house being haunted. They spoke to a lot of friends and family about the house being haunted. And so then when they did not tell the buyers that the house was allegedly haunted, the court found that as a matter of law, the house was in fact haunted, and that therefore the sellers should have informed the buyers. That's a bit unusual. I think you need to look state to state as to what you have to disclose when you're selling a house. I know some states have a rule that you must disclose if someone died there in the preceding years. So that's something you want to look into. Are you aware of that, Mark?
Absolutely. Yeah, invariably, almost every state has a provision that the seller must disclose if someone died there within a prescribed period. For instance, California is the last 3 years. Other states are the last 5 years. There's also some statutes out there that you've got to disclose if there was a murder that occurred in the house.
Right.
But I cannot imagine a judicial determination having been made that a house is haunted. I mean, when you get to the supernatural, that goes beyond the Constitution and laws of just about any jurisdiction.
Yeah,
any judge would imagine who made such a determination, if appealed, would have been overturned.
It was actually the appellate court. The trial court found that it was not haunted. This is I could get you the case name. It's a recent case. They call it the Ghostbusters ruling, but it's very unusual. And to your point, it's not. And to Sky's point, it's not something you can scientifically prove. I think that the court sort of was taking notice of the fact that because the seller was going around telling everyone that it was haunted, that therefore they would recognize that it was in fact haunted. Speaking of haunted house, I'm sorry, Mark. Go ahead.
So that's kind of bizarre.
It's a stretch. It's a stretch.
Yeah,
Speaking
even if it had been to the Court of Appeals in New York, which is the highest court in New York, that they would have upheld the appellate division of the Supreme Court, because it's an untenable, unsupportable finding.
What do you think of this idea of if someone's injured in a haunted house? There's a lot of cases where people go to haunted houses and they get so scared that they turn to run and they break a leg or they break their noses. I mean, some people have some serious damages. Do you have a sense about what the courts do in those situations?
Oh, absolutely. When you're the owner of premises, whether it's a house or a haunted house or any other premise like a restaurant or a store, you're under a duty to use reasonable care to ensure that people will not be injured by a dangerous or defective condition of property. When you're getting into the issue of haunted houses, there's a doctrine called assumption of the risk. And if there's no dangerous or defective condition of property per se, in other words, holes in the floor or wires or things where people might trip and hurt themselves or fall into something, but rather what it is that might cause the injury, being spooked or scared by somebody jumping out, you're going in knowing that. So under the law, you are assumed to have assumed the risk. Probably a double assumed, but you are assuming the risk when you enter that property that people are going to be doing these things. So as long as the property itself is safe and free of dangerous or defective conditions, there would be no liability on the premises owner.
That's right. That's what I found too in my review of the law on this topic. And now I want to make sure that I've hit one of the questions that Jillian asked is, this whole idea of trick or treat. Where does the trick begin and where does it end? Are you entitled as a trick-or-treater to inflict any sort of damage on a home or on a property and use as your defense, well, it was just a trick because they didn't give me a treat?
No, absolutely not. You'd still be charged with some form of vandalism or something, of a local ordinance of that type. And what's interesting, if you want to take this a step further, if the trick-or-treater causes injury or damage to the homeowner or the homeowner's property, and that injury or damage is the result of negligence alone, the parents of the trick-or-treater could not be held liable. So if a child is at the front door and quickly turns around to see others coming and accidentally bumps into a statue that may be there, knocks it down and breaks it, the child alone would be responsible for their own negligence. A parent cannot be held liable for a child's negligence. However,
that's right. I was just waiting for the however. Go ahead.
But a parent can be held liable and will be held liable for a minor's intentional torts or intentional conduct. So if a child walks up to a house and gets frustrated because he was given a baby mounds instead of a full-length mounds and throws a rock through the front window, that's an intentional act for which that minor's parents will be held liable.
That's right. Mark, you've been fabulous with helping us with the Halloween stories. Thank you so much for your time.
Sure. Well, to all your listeners and viewers, be safe out there. And in the event something looks suspect, just go the other way.
That's right. Thank you, Mark. I appreciate it.
All right. Be well now, Heather.